Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 329 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things compliance service related. Today I have back with me my good friend and colleague, James Koukios. James is a partner at Morrison Foerster, who the law firm puts out a monthly top 10 international anti-corruption developments newsletter. And today we are visiting about the firm's newsletter for March 2017. We have a very interesting discussion of the Lawrence Hoskins case, which is in front of the Second Circuit, including a review of the oral arguments and the challenge to the Department of Justice's position on the jurisdictional reach of the FCPA. James and I really go into the weeds on this one, kind of geeking out from a legal perspective about the positions of the parties and how the court's ruling could significantly impact the jurisdictional reach of the FCPA. We then take a look at the recently released OECD Working Group on Bribery Phase 4 reports for the United Kingdom and Finland. James explains what these phases 1, 2, 3, and now 4 are. I question about some of the issues raised, and James really goes into an explanation of what goes into these. We talk about the reports in the United States and what the OECD really brings to international anti-corruption enforcement. It's a fascinating discussion. I'm sure you will enjoy it. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox again, back for another episode of the FCPA Compliance Report. Today, I am extraordinarily pleased to have back with me James Koukios, partner at Morrison Foerster, to talk about the firm's March edition of the top 10 international anti-corruption developments. James, thanks for taking the time to visit with me today.
Thanks for having me again, Tom.
James, once again, just a fabulous resource for the compliance community, the compliance practitioner, law firms. Kudos to you and your team for putting this together. And as always, there's some really interesting issues in the report. And finally, we get a law issue to geek out on. And I've been waiting to really want to go into this with you because I think it's a fascinating case and gives us a lot of kind of meat to really talk about in light of the really lack of a lot of judicial rulings on the FCPA. So we've got the Second Circuit heard oral arguments in March on a challenge to the Department of Justice's position on the jurisdictional reach of the FCPA. It involved Lawrence Hoskins, a former Alstom executive. And so with that, I was wondering if you might be able to set the stage of what this appeal is on, and then we can geek out.
Sure. Sounds good, Tom. Always fun to be a geek. Didn't think so in high school, but now it is.
Yeah, it's cool now.
So very, very interesting and important opinion will be coming out of this oral argument. So as you mentioned, Lawrence Hoskins was a former Alstom executive. He was actually a UK citizen, and he was based in Europe. And really did not, at least for purposes of what he's charged with, have any physical contact with the United States. He didn't travel to the United States to take part in any of the activities that are charged. He was always in Europe or Asia for it. And the allegations essentially are, if you go back to the Alstom case, that Alstom and Marubeni conspired to bribe Indonesian officials in order to win a very lucrative power plant construction project called the Tarahan project in Indonesia. And the allegations were that the bribes were paid through two middlemen, two consultants, that Alstom and Marubeni would pay the consultants, and then the consultants would pass the money on to the Indonesian officials. And Hoskins is actually alleged to have been very, very involved in that decision. In fact, there's allegations about him delivering the news to one of the consultants that the consultant wasn't bribing the right people, so they're going to bring in a second consultant to bribe the right people, and that all took place though in Indonesia, not in the United States. So that's the allegation. Whether it's true or not, of course, is for the jury to decide later. But the allegations are really put him at the center of this bribery conspiracy. And by the way, Tom, I should mention one of the reasons it's important in an FCPA violation, allegedly, is that one of the Alstom subsidiaries that was going to be primarily involved in this power plant contract was based in Connecticut. So the DOJ charged both Alstom and Marabini with this conduct, and then charged a series of Alstom executives as well with this conduct, including Hoskins. And Hoskins challenged the jurisdiction of DOJ to reach him for FCPA violations on the grounds that he did not fit within the categories of people specifically enumerated in the FCPA. Again, as I mentioned, he did not set foot in the United States as part of this conspiracy, so there's no 78 DD3 jurisdiction. And he said that he was not an agent of the U.S. Domestic concern, the Connecticut subsidiary, because he was above them in the hierarchy, and he could not, therefore, be considered their agent for purposes of that. And he said because he could not be held liable as a primary person, then he could not also be held liable under conspiracy or aiding and abetting under the 1932 United States Supreme Court ruling in Gabbardi versus United States. So I'll pause for a minute, Tom, and let you be geeky now if there's anything you want to talk about for Hoskins.
Right. So the first thing I found, I guess I shouldn't say troubling, because if it's not available to be charged under the statute, it shouldn't be troubling. But is we have a actor outside the United States engaging in conduct for a company that I believe has jurisdiction, the U.S. has jurisdiction over, claiming that individually you couldn't reach him. So that sort of troubles me on one point. But even if that is not troubling, then we now move to the second part, as I understand it, which is that if there can be no personal liability individually, then you cannot be charged with conspiracy. And that really takes away or would negate a large swath of what the government can use to charge people. So did I get that right, or am I a little bit off base?
No, you did. And the district court in Connecticut agreed with the defendant that he was not among the class of people who could be held primarily liable for an FCPA violation, and therefore could not be held liable for conspiracy or aiding and abetting under this 1932 Supreme Court decision. And DOJ responded both with a legal argument, but also a policy argument that is exactly what you found troubling, Tom, because effectively what they argued, and what at least one of the Second Circuit judges during oral argument seemed to find pretty persuasive, was what this means is companies can simply set up a bribe desk overseas, make sure the people who are authorizing and working on the bribes never set foot in the United States, and then they can just organize bribes for everybody company-wide, internationally, around the world. And obviously, if you're DOJ, that's a particularly troubling potential for that to come out that way, because they wouldn't be able to charge a lot of FCPA violations as well. And then if you say, take it a step further, we're going to have the bribe desk over in the UK or France or somewhere else where there's no foreign bribery law, and just tell the folks back in the United States, don't worry about it, don't think about it, we'll find you a consultant, everything will be fine. Then there might be, setting aside the willful blindness issue, there could also be absolution for the folks back in the United States because they had nothing to do with it as well. So it is, I think DOJ has a good point that from a policy perspective, from an anti-foreign bribery perspective, it could be a very troubling ruling. Now, it's hard to read the tea leaves. At least one of the Second Circuit judges during the oral argument seemed to be going DOJ's way, but you never know with these things how the other two were thinking, or if maybe that judge was just playing these things out to see what it sounded like and is going to actually believe something differently. So it'll be very interesting to see. But one of the biggest issues, Tom, as you said, is it could really make it harder for DOJ to charge cases. Now, we went back and looked back in August of 2015 when this decision first came down. We actually went back and looked at whether this decision would have affected any of DOJ's cases in retrospect. And there's really only one corporate case that would have been affected, and that's the JGC case involving Bonny Island.
Right.
JGC was the one sort of entity involved in that case where it was only charged on a conspiracy basis, where there would be no other separate U.S. jurisdiction, physical nexus, or anything like territorial jurisdiction, and that as well. So for the most part, DOJ historically, their enforcement program would not be affected by this if you look backwards looking. But obviously, if companies knew this and said, we can just set up these foreign bribe desks, it could really cause issues going forward.
So I recall that the former Louisiana Congressman William Jefferson was convicted on one count of FCPA conspiracy while not being convicted on the underlying count of directly. Would that be inapplicable because he's a U.S. citizen?
That's right. That's right. He's a domestic concern, so he could be found primarily liable of an FCPA violation. And just because the jury did not find him primarily liable for an FCPA violation doesn't really affect the analysis.
Well, like I said, this is really a highly technical argument with a lot of policy implications and implications for the scope of what the DOJ can do going forward. Would you have, without asking you to read the tea leaves, any idea of when we might expect a decision, James?
I don't. I really don't. I'm sure the Second Circuit's very busy, so I think it might be a little hazardous to try to predict when a decision will come out.
Well, it's going to be fascinating to watch, and for all you law geeks out there, I'm sure it will be a very well-written decision, as I believe most decisions, if not all, coming out of the Second Circuit are, and it will give us a lot of gist to go over in the next coming months.
Yeah, this is definitely a case to watch.
So, James, I'd not like to turn to the OECD working group on bribery releases issued its first ever Phase 4 reports. And I think most of my listeners are familiar with the OECD, but they don't know what the phase reports are, and particularly this Phase 4 report. So I was wondering if you could just kind of walk us through what the phase process is and how we've gotten to Phase 4. Sure.
So under the OECD, there's obviously the Anti-Bribery Convention, which requires member nations to have an FCPA-like law. And you don't have to be a member of the OECD per se to be a member of the OECD Working Group on Bribery. So the Working Group on Bribery is actually larger than the OECD itself. There's about 40 members, and they all agree to submit to a peer review process where two peer countries do a very close and exhaustive study of another member country's, number one, laws, to make sure that the law itself is consistent with the OECD requirements for what the foreign bribery law should be. And two, actually looks at practical things like, are you enforcing the law? Are you advertising, for lack of a better word, to the business community that there is this law? Are you doing public outreach? Are you doing all the things that you're supposed to be doing under the Anti-Bribery Convention to make sure it's effective? And it's divided into three different phases. Phase 1, originally it was divided into three different phases: Phase 1, Phase 2, and Phase 3. Phase 1 tended to be more of a tabletop exercise focused on the actual letter of the law. Phase 2 was much more far-reaching, where the reviewing states would actually go to the country being reviewed, sit down with officials, sit down with civil society, and talk about, really get underneath the practical aspects of anti-bribery enforcement. And then Phase 3 was very similar to the Phase 2 in terms of really kind of looking at the practical application of the anti-bribery statutes. I actually had the great fortune of doing the Phase 2 for Russia, and I can tell you that it's a very, very comprehensive process. There are questionnaires sent out ahead of time that the country being reviewed has to respond to. The OECD has a permanent staff on hand that's really expert in this. They analyze things. They prepare great packages for the examining countries to use when we go over there and ask questions. And it's a really very searching process. In fact, it's been described as one of the most rigorous, if not the most rigorous, peer review processes in all of the treaties out there. I think FATF is also considered very, very searching, but this is kind of considered the model, the best version of the peer review process. And in fact, it's so important that many countries have gotten really, really scathing reports on them, and has really actually, in many cases, in several cases, resulted in actual changes to the law and enforcement. For example, the most famous case is the UK got blasted in these reports for having a bad law and bad enforcement, and that, in many people's view, helped lead to the UK Bribery Act and the SFO's aggressive enforcement of the UK Bribery Act. So it's a long way of saying that these phase reports and this peer review process is extremely important to anti-bribery enforcement going forward. And if you're a practitioner and you're curious about what the law is in any of the member states, they're really encyclopedic and kind of treatises on what they are. Very fascinating. I highly recommend them to practitioners, especially, of course, the Phase 2 report for Russia, which was brilliant because I did that, worked on that. But the OECD working group has been around for a while now, and they've actually gone through all three phases for many of the member states. For example, the United States has gone through the Phase 3 several years ago. My partner, Chuck DeRoss, was one of the folks who helped lead that up on the response side of that. And so then the question became, all right, we've done these phases. They've been very useful, but now they're done. And how do we continue to monitor countries? What do we do to make sure they're still complying? And what's the next phase? And so over the last couple of years, there's been a lot of debate in the OECD about what we should do for Phase 4. A lot of people are very concerned about what that would look like. And they finally agreed on a Phase 4 monitoring process last March 2016. And these reports that came out in March of 2017 were the first two under the Phase 4 monitoring process. They were of the United Kingdom and Finland. And by all accounts, it actually went very well. The agreed upon approach to Phase 4 ended up being very successful. And it looks like there's going to continue to be an evolution of phases going forward to make sure that countries continue to fulfill their obligations under the Anti-Bribery Convention.
James, with respect to the findings on Finland, I found those a little troubling. And the reason I did was it said that there was a, quote, discouragingly high, end quote, acquittal rate of foreign bribery cases that went to trial. And I'm a recovering trial lawyer, and I'm pretty much of the opinion that if you haven't lost a case, it means you haven't been to trial. And so I don't get too fussed when a judicial system works. I may disagree with the result, but I believe that procedural protections are in place for both the prosecution and the defendant. And if you go to trial, that it's up to the trial judge, the trier of fact, be it the judge or the jury, to make those decisions. So that if you get an acquittal, I don't view that as a failure of your anti-bribery efforts, your convention, your legislation, or indeed anything else wrong. So really, any thoughts on that recommendation?
Sure. The recommendation, Tom, was that really, I think it seemed to be, if you get underneath the recommendation, it seemed to be that the OECD working group thought that maybe they weren't taking these cases seriously enough, that they are complicated cases. It takes a little bit of a different skill set to investigate and present these types of cases at trial, and that maybe there was not enough sophistication and expertise in bringing them to trial. I think that was sort of underneath what was going on there. And I can tell you, I've tried a lot of cases like you, Tom, including 2 FCPA cases, and they are a little different. Not that they're completely different than all other kind of complex cases, but they have their own nuances, how to prove somebody's a foreign official, how to get overseas evidence, things like that. And so maybe there was a little bit of the OECD thinking that we need a little more specialization, a little more expertise in how to do these. The one that I thought was interesting, and so the recommendations were provide detailed information and training to judges, prosecutors, and investigators on the foreign bribery offense and its application, assign foreign bribery cases to courts or judges with specialized skills and experience, and enact clear and comprehensive legislation to protect whistleblowers. I don't know if you should really I don't know enough about Finland's exact system to know if these are good ideas or not. But if you kind of look at maybe the bigger picture, it seems like they were saying this is a complicated area, and you need to take it a little more seriously and give a little more training and experience to folks who are both trying and hearing these cases.
I guess I'm also informed by my father, who was an officer in the United States Navy, and his philosophy was once an officer, always an officer. If you're an officer, you're charged with knowing everything an officer is supposed to know, and if you don't know it, you better go learn it. And so I kind of ascribe that to people who call themselves trial lawyers too, that you're supposed to be able to know how to try a case, whether it's a car wreck or whether it's an FCPA or a RICO or anything in between. Looking at the recommendations, though, it does seem that they are a little bit beyond simply just trying cases to some of the other legislation in the country. So perhaps I was overly harsh, but I always just find it troubling when I see people who actually go to trial criticized for actually going to trial.
It's a good point, Tom, and I think there's another aspect, and I picked up on this when I was doing the phase 2 of Russia. In the United States, obviously, as you know and your listeners know, have actually dedicated units at the FCPA and at DOJ and SEC focused on FCPA, and it's worked very well. The SEC attorneys and the DOJ attorneys have built up a level of expertise that's been very successful. And I think what happens is, for much of what's going on in OECD Anti-Bribery Convention enforcement, they look to the United States, given the United States track record, as kind of a model. Not always. Obviously, different countries have different proceedings and different constitutional rights, for lack of a better word, and different mechanisms. So you can't always look one-to-one to the United States. But I think they do when it comes to these peer review process and they're looking at enforcement records. They look to the United States as a leader on how does the United States do it. And I think they see, well, the United States has specialized prosecutors for the foreign bribery offense, so maybe that's what we should have other countries do as well. And that sense was actually that was during the phase 2 of Russia that I participated in. A lot of people were saying that, and I said, let's step back from it. It has worked very well for us. But I don't think it's necessarily the way for every country to go. Let's give them some leeway and not be overly prescriptive. But I do think there's kind of a tendency to say the U.S. has specialized units. It works very well. So maybe that's what other countries should do as well. So now if I could turn to a finding, or rather a report issued by Trace International, which found there was a significant increase in global bribery, anti-bribery, anti-corruption enforcement. And this is something that you and I have really talked about on each of our podcasts together, how the case law or the case enforcements have been ramping up. And now we have an excellent report which quantifies this. So this seems to me to be really confirming what you and others in private practice bar have said, what the regulators have told us when they speak at conferences. Dan Kahn and Kara Brockmeyer have talked about this. So really anything in the Trace report that you found new or different, or is this really just confirming what you anecdotally knew? I think definitely it's confirming anecdotally what you and I and all the other folks you mentioned already knew, Tom. So just for your listeners, they found that Trace found by reviewing enforcement trends in 2016 that U.S. enforcement actions had doubled from 15 to 30, and that non-U.S. enforcement actions had more than doubled from 4 to 10 since 2015. So that obviously doesn't get to all the things out there. A lot of what enforcement agencies do is non-public, so the numbers could even be more dramatic than those. But I think that the overall thrust of the Trace report saying that enforcement has increased greatly in the last couple of years is spot on and really confirms what, as you said, we already kind of knew.
Well, James, as always, this has been a really fun podcast for me and great for the listeners. And once again, great information in the Morrison Foerster report. We'll link to it in the show notes, and I look forward to the April report and perhaps visiting with you again on this.
Thanks, Tom. I look forward to it.
This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate the podcast as it would help in our rankings and help get the word out about this top podcast in compliance. Also, if you have any questions, you feel free to email me at tfox@tfoxlaw.com. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report.